Hello and warm greetings. Welcome to the Analyst by Vajiram and Ravi, where we would try to comprehensively analyze 7 articles in 2 different sections. In the analysis part, we'll first have a discussion with respect to the recent verdict of the Supreme Court on the state's power to acquire private property for the common good. In the second article, we'll have a discussion with respect to the STEM education and research in India, the issues plaguing the sector, and the way forward. Then, in the simplified section, we'll have a look at 5 different articles with specific reference to the UPSC Prelims 2025 along with the value addition. So stay tuned. So coming to the very first article of the day, this is with respect to the recent verdict of the Supreme Court on the acquisition of private property by the state. So recently, the 9-judge constitutional bench of the Supreme Court has very categorically said that not every resource owned by the private players can be considered as a material resource of the community so as to subserve the common good. See, the concept of right to property in India has been ever evolving, right? And we'll see today, we'll discuss in detail that what this construct of right to property is all about, what is the essence of Article 31A, 31B and 31C, and on what basis the Supreme Court has reached to this conclusion, right? Now, this is a part of GS2 Constitution, features, amendments and significant provisions. Now, let's study this topic in complete detail. Let's first talk about the right to property. See, the debate starts with the notion of individual versus the society. That is, the individual rights versus the obligations of the state towards the society, right? So originally, the fundamental rights under 19 subclause 1 subclause F and Article 31 provided for right to property as a part of the fundamental right. And it very clearly said that no person shall be deprived of its property except by authority of law, right? Now, with these rights available to the citizens, it led to a lot of conflicts, right? Conflicts because there were claims made by the individuals with respect to their property rights. And then there were the socio-economic reforms, which were the obligations of the state, including the land reforms, right? So on one hand, you have the individual who wants to protect his property. On the other hand, you have the state who wants the equitable distribution of resources, right? So that led to the conflict, right? Then what we saw was that it was in the year 1978, we had the 44th Constitutional Amendment Act, and this abolished the right to property as a fundamental right. And it made it a constitutional right, that is under Article 300A of the Indian Constitution and in the Part 12, right? Now, the Article number 31 has been a bone of contention for years. And that is the reason what we see is that subsequent amendments have taken place with respect to this construct of right to property. Be it the First Amendment, be it the 4th Amendment or the 7th or 25th, 39th, 40th, 42nd, right? So this remains a bone of contention. Now, what you need to understand is that it was the first Constitutional Amendment Act in the year 1951, which introduced Article 31A and 31B. Now, what are Article 31A and 31B? See, what 31A does is that it basically saves 5 categories of law. For example, if a state makes a law with respect to the acquisition of states, the acquisition of estates, or if the state makes a law with respect to the amalgamation of corporation. So you have a list of 5 types of laws which are there in this particular 31A. Now these laws, they are actually protected against the possible infringement with respect to Article 14, that is with respect to equality before law and equal protection of laws, and Article 19, that is right to freedom of speech and expression, among others. So what it does is that it creates a sort of an exception to these 5 categories of law, that you cannot basically say that any law which is made with respect to these 5 topics, that is actually invalidating the right provided under Article 14 and under Article 19. Now, it also gives a guaranteed right to compensation. That is, when the state acquires or when the state requires that particular private property, the state has to adequately compensate. That is what Article 31A does. Now, talking about Article 31B, see, 31B, what it does is that it makes a particular schedule, that is the 9th schedule. And it says that whatever rules and acts are placed in the 9th schedule, they are immune to any fundamental right which is there in the Constitution of India. Right? So what you need to understand is that in 31A, what we are doing is we are saying that if the state makes a law which has a link with 5 categories of those provided in the 31A, then that if infringes upon any aspect of Article 14 or Article 19, then it would not be invalidated. What Article 31B is saying that you have a particular schedule, 9th schedule. Now, if any act or rule is placed in the 9th schedule, then that would become immune to any fundamental right which is provided in the Constitution of India. Now, it is simple to understand that the scope of Article 31B, it is much wider than 31A. First, because that only 5 categories of laws are protected in Article 31A, right? Whereas on the other hand, what you see is in 31B, any law can be put in 9th schedule. Second is that in 31A, the protection is being only provided for Article 14 and Article 19. Whereas in 31C, the protection is being provided for any of the fundamental rights. So you just need to remember that. Now, what you need to remember is one of the very prominent case laws in India, that is IR Kolio case of 2007. Here, the Supreme Court very categorically said that, see, in the year 1973, we all know that we had the famous Keshav Bharti, where the Supreme Court came up with a basic structure doctrine. Supreme Court said in this particular case that any law which has been put in the 9th schedule after the date of the judgment of the case of Nanda Bharti, that is actually subject to the judicial review power of the courts, right? So the parliament cannot say that it is immune to the judicial action. No, the judiciary, if it finds that that particular law is an infringement with respect to the basic structure of the Indian Constitution or any of the fundamental right, then it can be declared as ultra virus, right, or unconstitutional. So that is what you need to know with respect to these 31A and 31B. Now, let's talk about 31C. See, we all know that India is a welfare state. What do you mean by welfare state? That India has obligations towards its citizens, primarily, mostly with respect to the vulnerable sections of the society. Now, this makes the obligation for the state to ensure the equitable distribution of resources, right? And again, if the state wants to make sure that it distributes the resources equitably, it has to have the ownership of the resources, right? So that was the reason that it was the Banking Companies Act of 1969, where a lot many private banks were actually nationalized. Now this case was taken up in the Supreme Court in the what we call as famously as the R.C. Cooper versus Union of India or bank nationalization case, where the Supreme Court invalidated this particular act, right, and said no. What we see is that we have a right to property with respect to the individuals, and that cannot be arbitrarily infringed. Now, because of this, what happened was that we had the 25th Constitutional Amendment Act of 1971, where Article 31C was provided. Now, I have given the exact wordings of the verbatim of this particular changes which were made. Now, this particular amendment said that no law giving effect to the policy of the states towards securing these principles specified in Clause B and Clause C of the Article 39. So first let's talk about what are the clauses 39B and 39C. Article 39B says that the state shall make policies in such a manner that it can ensure that the ownership and control of the material resources of the community are so distributed so as best to subserve the common good. That is Article 39B. What Article 39C says, that the state should make policies in such a way so as to ensure that the operation of the economic system does not result into the concentration of wealth and means of production to the common detriment, right? So understand, what we are saying is that these are socialistic trends. What we are trying to focus upon is that we are giving importance to the society and not the individual, right? So that is the reason that that various governments, they actually came up with these policies of different reforms, and then finally we had this 25th Constitutional Amendment Act, which included this 31C, and it said that no law giving effect to the policy of the states towards securing the principles specified in Clause B and Clause C of the Article 39 shall be deemed to be void on the grounds that it is inconsistent with or takes away or abridges any of the right conferred by Article 14, Article 19 or Article 31. And no law, now this is the second provision, no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy, right? So you have got two provisions. First is that if the state is making a law which is with respect to giving effect to 39B, the principles enshrined in 39B and 39C, that shall not be called into question. That it is infringing Article 14, Article 19 and Article 31. The second aspect is that it cannot be questioned in the court of law, right? So just remember this. Now, what happened was that this particular amendment was challenged. And we had the famous case of Nanda Bharti, also known as the case of Nanda Bharti versus State of Kerala. In this particular verdict, the Supreme Court, as we all know, came up with this beautiful doctrine, that is basic structure doctrine. Ever evolving doctrine. What we call is that it is not a rigid doctrine, right? It is ever evolving. And it said that certain principles, certain fundamental principles of the Constitution cannot be tampered with, right? It's not like the Parliament at its own whims and fancies can basically amend those principles. Those principles should be rigid, right? That is what the basic principles are all about. Now, what the Supreme Court said, that it invalidated a portion of the 31C. That is, which portion? The second portion. That is, it cannot be questioned in the court of law. Supreme Court said that judicial review is a part of the basic structure. So how can you say that we cannot question this? We can definitely question in the court of law. Now, again, once the Supreme Court did so, it opened the door for the court to examine different laws. That is, now courts were basically in a position to determine that if a state has made this particular a law, which is in principle with 39B and 39C, then the courts must ensure that yes, the particular law is in line with the principles enshrined with that particular 39B and C or not, right? So it was left to the judiciary to decide whether the particular law is really in line with those principles or not. Now, next what we see is that we had the 42nd Constitutional Amendment Act of 1976. Now, this expanded the protection under Article 31C. That is with respect to all or any of the principles laid down in Part 4 of the Constitution. See, please understand that we have got Part 4, which talks about the directive principles of state policy. Again, these are the directives to the state. These are the directives making sure that the state should make its policies, its formulations in such a way that they should be in line with these principles. But they are not enforceable in the court of law. That you need to remember. So what 42nd Constitutional Amendment Act of 1976 did was that it expanded the overall horizon of 31C because it included all the principles which are enshrined in the directive principles and not just Article 39B and C. Now, this particular amendment was basically challenged, and it was the famous Minerva Mills case of 1980 where the Supreme Court struck down these clauses. Again, there were basically two amendments which were done. First is that any of the directive principles, if the state is making any law and it is trying to implement any of the directive principles, that cannot be called into question. That was the first. Second was that it basically made sure that the judiciary cannot question that particular amendment, right? That particular law. So again, these clauses were actually struck down by the Supreme Court in the Minerva Mills case, and this basically underscored the limitations on the Parliament's authority. That is, Parliament is not authorized to make any kind of amendments. That has to be in line with the constitutional mandate or the constitutional principles. Now, two questions arise. First is that you had significant amendments which took place, and then you had got significant rulings which were actually delivered by the Supreme Court. Now, the question is, what is really the status of 31C? Because again, what we saw was that in the Minerva Mills case, these clauses were actually struck down by the court. So what is the position with respect to Article 31C? So the court has very categorically said, very clearly said, that the position is with respect to post-case of Nanda verdict. That is, only those laws which seek to implement the principles which are there in 39B and 39C, they are only protected. That is the first thing. Second question is whether the government can acquire and redistribute privately owned properties if they are deemed as material resources of the community. Whether the state has absolute right over the privately owned properties. That is the second question. Now, in order to discuss this particular question, what the Supreme Court actually talked about was that we have the directive principles of state policy, as I just mentioned. So these are nothing but the guiding principles. These are the principles which the state has to follow, but they are not directly enforceable. And we also have the Article 37, which very clearly says that these provisions shall not be enforceable by any court. But these principles are nevertheless fundamental in the governance of the country. And the state, it shall be the duty of the state to make sure that they apply these principles while they're making any law, right? So this is a very important article which signifies the importance of directive principles. Now, then we have got Article 39B. Now, it also tries to give the obligation of the state to create a policy. That is, what it says is that the state should make its policy in such a way that the material resources of the community are distributed so as to subserve the interests of the common good, right? So as to subserve the common. That is what Article 39B provides for. Again, the Supreme Court has had different interpretations of this Article 39B. That is the material resources of the community. So what we are trying to say is that the word material resources of the community, which is there in Article 39B, the Supreme Court has had different interpretations with respect to that. So we had the very first case, that was the state of Karnataka versus Sri Ranganath Reddy of 1977, where in a 7-judge bench, in the proportion of 4:3 majority, said that the privately owned resources did not fall within the ambit of the material resources of the community. What does it mean? It simply means that state cannot add its whims and fancies. A state cannot arbitrarily acquire any property, right? So what we are trying to say is that private owned property is different from that of the other property, the state property, right? But what we had was that in this particular judgment, we had the very important dissenting opinion by Justice Krishna Iyer, where he said that the state should have the control with respect to the ownership of private resources, so that it can basically make sure that the resources are equitably divided. Resources are equitably distributed among different sections of the society. That is what the opinion of Justice Iyer was. But in this particular case, what we saw was that the majority said that no, all the private property cannot be a part of the state, as that is, it cannot be a part of the materials resources of the community. Then in the second case, we had the Sanjeev Coke Manufacturing versus Bharat Coking Coal of 1982. Now, in this particular case, we had Justice O. Chinnappa Reddy. He basically affirmed Justice Iyer's opinion. That is, he said that the state has the complete authority to acquire any private property, any private resource, if it is trying to implement a particular directive. If it is trying to implement the directive so as to subserve the common good, it can basically acquire any private resources. That is what this particular judgment talked about. And the exact wordings of the judgment were, takes within its stride the transformation of wealth from private ownership into public ownership and is not confined to that which is already public owned. That is, it's not just confined to the public owned, but the state can also acquire and have the ownership of the privately owned resources. Now, in this particular judgment, what the Supreme Court has very clearly said, that the state does not have the absolute power to acquire all the private resources, right? It can do so, but it can only do so in certain circumstances, where the circumstances are needed for that, right? Again, what we are trying to say. So first we'll see what the Supreme Court has said. So Supreme Court has said that not every property owned by the individual can be material resources of the community. Again, what we are trying to emphasize the fact that since independence, we have had different forms of economic systems. Please understand that in the years of 1950 and 60s, we followed a mixed economy system where import substitution was focused upon, where the focus was on the heavy industries. Then what we saw was that there were some socialistic trends in the 1960s and the 1990s. And then what we saw was that it was in the year 1991 that we had the LPG, the famous liberalization, privatization and globalization reforms. So we have had a different chart of economic progress. Now, again, what the majority judgment in this particular verdict has said, that you really cannot restrict the state. The constitution cannot have its own economic system, right? So, as Justice Chandrachud, he also says that, as Dr. B.R. Ambedkar mentioned, that the constitution does not prescribe, the constitution does not lay a particular economic and social system, because if it would be doing so, then that would basically take away the liberty of the individual. That is what Dr. B.R. Ambedkar said. So again, what we are trying to focus is that, see, this system, the economic system, needs to evolve with the times, with the needs of the society. So right now we have a system where we have in some sectors the dominance of the state, where in some sectors, in the majority of the sectors, we have also the participation by the private players. So that is what the Chief Justice of India has also said in this particular judgment. That is what you need to know, and this is a comprehensive picture with respect to the right to property, right? Now, before we go to the next topic, we have a main question. The question says, Article 31C of the Indian Constitution sought to harmonize the directive principles of the state policy with fundamental rights. Critically analyze the evolution of Article 31C with reference to the significant constitutional amendments and the Supreme Court judgments. So do write a particular answer in this question. Now, before we go to the next topic, I have 3 questions for you. The first question is, you need to tell me that who presides the joint sitting of the 2 houses of the parliament. Second question is very simple. It is, what is the difference between fiscal deficit and primary deficit? The third question is that which 2 countries they basically surround the agency, right? So you need to tell me the names of those 2 countries. Give the answer and let me assess your preparation, and let me see who answers first in the comment section. So coming to the next article, this is with respect to the revitalization of STEM education and research in India. So what this article says is that while different colleges, IITs and universities have expanded the access to education, what the studies have revealed is that the students, the majority of the students who are graduating from these colleges, they lack the basic skills which are required by the industry. So what we have been focusing upon is the skill gap which is prevalent. That is, the skills which are being imparted by the educational institutes, they are not in sync with the skills which are demanded by the industry. And that obviously affects the overall research in the STEM domain. Now, this is a part of GS2, social sector education. Now, let's first talk about what is STEM, right? So it was in the year 2001 that we had the United States National Science Foundation, which actually coined this acronym STEM. Now, this stands for the curriculum, where the idea is that you are actually integrating 4 specific disciplines. That is science, technology, engineering, and mathematics. So what we see is that it is not the subjects are not being studied in silos. What we are seeing is that we are having a sort of an interdisciplinary approach. We are having an applied approach, right? And that is what the basic fundamental of STEM is all about. Now, this becomes really important for India because we have a lot of engineers and scientists who are passing out from the colleges on an annual basis, right? So this particular sector becomes relatively more important for India. We also have Article 51A of the Constitution of India, which says that it is a duty of every citizen to promote the spirit of inquiry, to promote the scientific temper, right? So this also is a boost to this particular field. Now, what is the significance of STEM education? The very first is that, see, again, what we are seeing is that we are witnessing Industrial Revolution 4.0, right? Where we have the disruptive technologies, different technologies which are actually infusing in different sectors, be it the manufacturing or transportation or agriculture, right? We have different technologies like artificial intelligence, machine learning. So we need to have those human resource with us who are adequately trained in these particular technological domains, right? So what we are trying to say is that there is a need of critical thinkers and next generation innovators, and that is only possible that if we give adequate importance to this particular domain, STEM domain. Next is that this particular National Science Foundation of the US study, it has shown that 80% of the jobs which would be there in the coming decades, they would need some sort of engineering or mathematics knowledge with the candidate, with the student. So it also emphasizes the importance of STEM domain, right? Now, what are the issues and challenges which are actually associated with the STEM education and research in India? The very first is the quality of education and curriculum gaps. What we have been saying is that there is the issue, a consistent issue of the skill gap. That is, you have the industry which demands a particular skill set, but that is not being provided by the educational institutes. Because what we see is that these educational institutes, they have outdated curricula. They are not focusing upon the recent advances in the technology, right? Then what we see is that insufficient attention is being paid to the practical exposure. That is, there is the emphasis on the theoretical learning rather than experiential learning, rather than practical learning, right? Then what we see is that there is the rigid structure of many educational programs, right? These programs are not in sync with the recent technological developments, or they are not flexible. They are very rigid. And that is something which actually retards the progress of the students in the STEM domain. Next is faculty shortages and inadequate training. See, we already have less students in the country which are actually expert in this particular domain. So ultimately that is a pool from where we'll get the faculties. So what we have is we have a shortage of faculties in this particular domain. And again, what we are saying is that there are difficulties in the recruitment, in the retention of the experienced educators. Because see, understand, if you have an experienced educator, if you have an experienced faculty in the STEM domain, obviously he or she would have good opportunities to go somewhere else and earn better, right? Not, let's say, that's the reason what we are seeing is that you have a significant brain drain, and that we'll also discuss now. So what we are seeing is that we have the shortage of these faculty, experienced faculty. And again, in India, what we see is that there is the burden of both, that is research and teaching. In India, we are not specifically focusing upon research. What we are saying is that these faculty members, they are also doing the research part-time basis, and then they are also focusing upon the teaching requirements. So what it does is that it leads to suboptimal returns with respect to the research, right? Next is infrastructure, funding, and research facilities. See, these research facilities, if you really want to compete with countries like China and the US, you need to have those research facilities which are state of the art, which are at the best level, right? Which are providing all the equipments and the necessary, assembly lines and everything. But again, what we see is that we in India, we have dearth of resources, and that is what leads to the backwardness with respect to the infrastructure, with respect to the funding constraints, and with respect to the research facilities. Next, what we see is that if you really want to have research in the cutting edge areas, be it artificial intelligence or quantum computing, you need to have supercomputers, you need to have big data centers, and that is basically a cost intensive process, right? Then there are difficulties with respect to the securing of grants. See, understand, the process in India says that you have bureaucratic hurdles. That is, the grants are not released on time. And these projects, these research projects are very time sensitive projects, right? So they need adequate amount of money at the right time. But what we are seeing is that there are delays with respect to the disbursal of the amount, and that leads to suboptimal results. Next is lack of industry academia collaboration, right? So what we are seeing is that the curriculum design, that is not basically being made on a consensual approach. That is, we don't see the participation of industry in the overall formulation of the curriculum. We only have the professors in the colleges, the different team members who are actually making these curriculum, and that is obviously is not in line with the needs of the industry. So what we see is that this particular curriculum, it does not reflect the needs of the industry, and therefore the research, it lacks the practical relevance, and there is nil industry involvement in the curriculum design, internship, and research, right? Next is, as I talked about, there is significant brain drain, right? So what we see is that we studied that in India produces annually, a lot of engineers and scientists. But because of the good earning potential they have in the other countries, because of the good research facilities they have in the other countries, they basically move to the new areas. And that is what leads to the brain drain. So ideally they can stay here and they can work in the different institutes, but not their fault, because if someone is getting a very good opportunity outside with better research facilities, so that is basically an incentive for them, right? So that is what we see, that there is dearth of these researchers and scientists in the country, right? And this limits India's potential with respect to the research output. Next is, there is widespread gender inequality. See, again, we are sure, we know that there has been tremendous improvement with respect to the participation of females in the primary education or the secondary education. But still, if we talk about the higher education, the participation is lesser compared to males, right? So what we see is that there is limited access to quality education with respect to women, and with respect to the leadership roles also, right? So we studied in the past that we have got this glass ceiling effect, right? So there are some unconscious biases which are prevalent in the society against these females, and that is what leads to the situation where they are not given the leadership roles. Next is policy implementation, very important aspect. See, Indians are very good at making different policies, but when it comes to the implementation, we definitely suffer, right? So what we are saying is that we had the new education policy, right? Still, the overall aspects of the new education policies have not been infused in the overall education curriculum, right? So there are issues with respect to the implementation also, right? So different new education policy is a set of the comprehensive guidelines which seeks to overhaul the overall education system in the country. But still what we are saying is that many of the education institutes in the country, they have still not abided by the policies, by the guidelines which are mentioned in the new education policies. Now, what this particular editorial highlights, what the issues are with respect to the STEM research in the country. What it says is that despite the expansion, many graduates lack the skills required by the industries. We have already discussed that there is wide skill gap present, right? Next, the number of students, and see this skill gap, it is also highlighted. It was also highlighted by the India Skills Report of 2021, which said that majority of the youth in the country, they are unemployable, right? Because of the lack of skills with them. Next, number of students pursuing the higher education has declined. Again, if you have the shortage in the number of students who are pursuing this STEM, obviously it would lead to the faculty shortages, and then it would hinder the initiatives, especially in cutting edge areas, be it cloud computing, be it artificial intelligence. Then the core issue which is highlighted in the article is the quality of education. Again, the quality of education is not up to the standards. And the reason being provided is that the faculty members, they are actually focusing more on the research output and they are not focusing upon the pedagogy. What the particular authors are saying is that you need to have adequate and in fact more emphasis on the teaching aspects. So that, see again, the promotion in these colleges and institutes, it is based on the number of citations a particular assistant professor or a professor receives, right? The number of research journals he has in his pocket. So again, what we are trying to say is that because of this, what happens is that that particular person is unable to deliver on the teaching aspect. And teaching aspect is really crucial when you talk about infusing those research inquisitiveness, those potential in the candidates, right? So again, once we have this situation, it leads to poor quality graduates, and then it creates a vicious cycle that affects the overall industry standards, the research in the country, and the overall output. Again, the writers have emphasized on the data. They have given a data, and they say that we have got different institutes, premier institutes, be the IITs, be the NITs, be the triple ITs, and they basically have the 5% of India's undergraduate student. So please understand that almost 95% of India's undergraduate student, they are in those colleges which are not as resourceful as these colleges, right? Next aspect is a very good number is provided. It says that we have IIT Bhubaneswar. The writers are trying to make a comparison. We have IIT Bhubaneswar, which has 60 seats in the computer science domain, right? And on the other hand, we have got the other university, KIIT University, which has almost 2,000 seats in the same domain, in the computer science domain. So what the authors are saying is that we have very less seats when we talk about the public funded institutions, and that too quality institutions, right? Next aspect is what should be the way forward. The first is there needs to be an adequate focus on enhancing the teacher training. Teacher training becomes very important. See, we always focus upon this aspect of making sure that students are given this particular training. A student should be given vocational training. Students should be taught these skills. But that is only possible once we have got good teachers with us, right? Once we have got good teachers who have those requisite skills with them so that they can impart those skills to these students. So what we need to do is we need to have professional development programs which focus upon the STEM aspect, which focus upon the STEM domains, be it artificial intelligence, be it machine learning, be it cloud computing, right? Then incentives should be given to qualified teachers. Once you have a pool of qualified teachers, you need to give them incentives. For example, if you want a particular qualified teacher to go into the rural areas, you need to basically compensate adequately. Give him a higher salary, right? So these are the incentives which need to be provided. Next, increasing the infrastructure investments. Very important. Again, as we talked about, that research, if you want to compete with the other countries in the cutting edge areas, you need to have a very strong state-of-the-art facilities, the best possible facilities. And for that, more resources are needed. And again, these resources would then support the experiential learning, not just based on theoretical concepts, but based on experiential learning. Next is digital connectivity is very important. If you want that different, to increase the pool of candidates in the STEM domain, then digital connectivity becomes really important, right? Especially when we talk about the rural areas, that is increasing the accessibility in different areas, be it the rural areas or even the remote areas, let's say the northeastern parts of the country or the hilly regions of the country or the backward regions of the central India, right? Next is promoting the industry academia collaboration. Very important. We need to have the industry in the overall designing of the curriculum so that they are in a better state. See, they are in a better situation to decide that what are the industry trends, what is the demand in the country, right? And what all technologies the students need to know. So their input is very crucial, right? So as to help align the education with the current market needs. Next is public-private partnerships. We always focus upon be it the public institutions or the private institutions. No, what we can have is a sort of a model where we have both the public as well as the private players who are actually collaborating, or in fact the NGOs, or in fact the non-profit organizations who are coming into this domain and working in the STEM domain, right? So that would lead to more innovative educational models and subsequent research output. Next, what the article talks about is, it gives a way forward. It says that there needs to be a rebalance, focus on the pedagogy and research. Again, as we talked about, that the teachers need to focus more upon the teaching aspects, not just related to the research. Because again, why they're focusing upon the research is because that is a criteria, that is a parameter to decide their promotional aspects, right? So that should basically, what we need to do is the ranking systems. It needs to emphasize on the research. What it is doing is currently is it is emphasizing on the research output, but it need to focus upon the teaching quality also. It needs to focus upon the kind of mentorship which is being provided. And again, there needs to be incentives for such teachers, for such faculty members who are actually focusing upon this pedagogy or teaching quality or mentorship, right? Next is change faculty promotion criteria. That is, the criteria needs to include the teaching aspect with respect to the promotional incentives, right? The promotional avenues of the particular teacher, right? That should include the teaching aspect and not just the research output. Centers of excellence can be created in pedagogy so that they are in a better situation to basically have a good command over different STEM domains, right? Then explore joint degree agreements. See, what we are trying to say is that there can be a collaboration between the research institutions and the teaching institutions. Let's say you have a final year student, a very bright student in the teaching institutions, right? So that student can be made to go to a research institute in his or her final year. And over there, that person can basically engage in different research activities. And then that person can be awarded a degree of both institutes, right? That would serve as an incentive for the students because they would really want to go in such research institutions, right? So that is what we are focusing upon, that there has to be collaboration between the teaching institutes and the research institutes. There should be a focus upon the faculty exchanges and different collaborations between these institutions. So that is what the whole crux of the article is, that definitely we have made progress when we talk about the STEM education and research in the country, but still there are wide loopholes present, and therefore what we are trying to emphasize is that we need to have these steps in place so that we can ensure a more robust ecosystem, STEM ecosystem in the country. That is what you need to know. Let's talk about a mains practice question. The question says, STEM education is pivotal for India's progress in research and technological innovation. Despite several initiatives, STEM education and research in India faces numerous challenges. Discuss the issues and challenges associated with the STEM education and research in the country and suggest measures to overcome them. 15 marks, 250 words. Do write a particular answer on this question. So coming to the simplified section, we have got the first article which talks about the importance of dedicated freight corridors. Now, we have had a research done by the New South Wales University in Australia. Then that particular study, it highlighted that how this particular DFC, dedicated freight corridor, is contributing to the overall GDP of the country and how it is basically boosting the overall rail revenues. Now, this is a part of infrastructure and railways. Again, what the article says is that the gist of the article is that we have had this project implementation started in 2006, and we have had the Eastern Dedicated Freight Corridor and the Western Dedicated Freight Corridor. Because of that, what we have seen is that there has been significant benefits to the overall economy, right? And that has also led to making the overall logistics sector in the country more robust. Please understand that India has been focusing upon enhancing the overall logistics. We have had discussed this particular aspect in many of the analyst sessions, where we actually discussed that the costs with respect to the logistics in the country are very high when we compare it with respect to the developed countries. So in India, it ranges from 12 to 13% of the GDP, while in the other countries, the cost with respect to the logistics in the developed countries, it is somewhere between 8 to 9% of the GDP. So we need to focus upon reducing the logistics costs. And how we can do that? We can do that by making these transportation services more efficient, right? More time responsive, right? So what the article says is the dedicated freight corridors are improving the India's GDP and adding significantly to rail revenues, the research has shown. Now, this study has shown that it has basically led to the reduction of the freight cost and travel time due to the DFCs, dedicated freight corridors, and helped to reduce the prices of commodities by up to 0.5%. Corridors have contributed to 2.94% when we talk about the revenue growth in the railways, if we talk about the time period from 2018-19 till 2022-23. Now, the study was basically with respect to the Western Dedicated Freight Corridor, right? Now, what are these dedicated freight corridors, right? So, these are the specific routes for the freight transportation which offer higher transport capacity due to faster transit of freight trains, right? So you have got specific routes which are designated for these freight trains, right? So what it leads to? Faster transit. Double stack container. So you can just see in this image that we have double stack. And this basically leads to more efficient and more loading can be done, and then that can lead to more effectiveness in the overall transportation. And heavy haul trains. This improves the overall supply chain, industries, logistics players located at economic centers along the way, and it also leads to the overall export-import, right? The Ministry of Railways, it basically started the construction of the two DFCs, that is the Western Dedicated Freight Corridor and the Eastern Dedicated. So we have got the Western Dedicated and the Eastern Dedicated Freight Corridor. The 1,337 Eastern Dedicated Freight Corridor from Sonnagar in Bihar to Sanewal in Punjab. Then we have 1,506 kilometers Western Dedicated Freight Corridor from the Jawaharlal Nehru Port Terminal in the Mumbai to Dadri in Uttar Pradesh. Back in 2006, the Eastern Dedicated Freight Corridor as of now is complete and is commissioned with feeder routes to different coal mines. Please understand, look at the map. We have got the Eastern Corridor. These are the areas rich in coal mines. So we have got the feeder lines. Which are actually connecting to the Eastern Dedicated Freight Corridor, and it is resulting into more efficient transportation of coal to the thermal power plants, right? The Western Dedicated Freight Corridor is 93% commissioned with feeder routes serving various cement plants. Please see again here that we have got numerous cement plants located in this part of Gujarat. So it is also leading to the transportation of cement very efficiently. And the large ports of Mundra, Kandla, etc. It is expected to be fully complete by December 2025. As of March 31st, 2024, almost 94,000 crores have been actually spent in executing the dedicated freight corridor project. Now, why these DFCs were actually needed? The article gives us 2 points. First is that we have had the overutilization of the railway's golden quadrilateral. Please understand that we have 4 metropolitan cities which are connected by the railway network. So we have got the Delhi, Mumbai, Chennai, Havda. And then we have got the 2 diagonals, that is Delhi, Chennai and Mumbai, Havda. What this article says is that it only comprises of 16% of the overall rail network in the country. But it basically carried more than 58% of the passenger trains and 58% of the revenue earning freight traffic. So what you're seeing is that these are overburdened. These routes are overburdened. Therefore, what you had to do was that specific routes were made so that is only meant for the freight, right, and not for the passenger, right, so that you can have specific routes designed and dedicated for the freight transportation. Another reason is that the railways dipping share in the total freight traffic. We have had the National Rail Plan. Now, this envisages that the overall share of the freight traffic by rail should increase to 45% by 2030. As of now, we have dominance of the road model of transport. Again, this National Rail Plan is emphasizing to increase the rail share to 45% by 2030. And this actually needed the creation of DFCs. The creation of DFCs was in the railway budget of 2005-6. Prime Minister Manmohan Singh laid the foundation stone of the Eastern Dedicated Freight Corridor in October 2006. The foundation stone for Western Dedicated Freight Corridor was done on October 30, 2006. Then we have a special purpose vehicle, a specific organization who's heading all these, who's managing these dedicated freight corridors. We have the Dedicated Freight Corridors Corporation of India Limited, incorporated as a special purpose vehicle for the construction, operation and maintenance of these corridors. Also, we had recently Prime Minister Modi in March, he inaugurated the latest 3 stretches of 135 km in the Western Dedicated Freight Corridor, 179 km and 222 km in the Eastern Dedicated Freight Corridor. Now again, what you need to see is that the status is provided as on an average 325 trains are running on a per day basis. Now this is 60% more than the last year. So what we're seeing is that more and more number of trains are running on these dedicated freight corridors, and that is leading to more efficient transportation of these goods. The freight trains on the dedicated freight corridors are faster, heavier and safer. DFCs have carried over 232 billion gross ton kilometers, 122 billion net ton kilometers. Now, according to DFCCIL, more than 10% of the freight running of Indian Railways is now handled by DFC. Now, this is a good number. So, you have got a particular dedicated freight corridors who are actually handling the 10% of the overall freight, right? The comprehensive and holistic study of the impact of DFCs in the Indian economy is yet to be actually studied, right? So we have got 4 more proposed corridors. The first is the East Coast Corridor, which is set to connect the Kharagpur-Vijayawada. Then we have got the East-West Sub-Corridor first, which is set to connect the Palghar with Dankuni. Then we have got the East-West Sub-Corridor second, that is Rajkharsavan and Andal. Then we have got the North-South Sub-Corridor, that is Vijayawada and Itarsi, right? So you need to just remember which is information which is provided here. Now again, what has been the basis of Australian University study? The research is based on different kinds of data, including the freight cost, industry inputs, population data. It also factors in other inputs, for example, regions, industries, consumers, and overall improvements. The study found that the introduction of DFCs, dedicated freight corridors, provided great benefit in the western regions due to significant reduction in the freight cost, right? Second reason is that it is also talking about social equalizing effect. That is, those states that have lower per capita GDP, they have experienced significant benefits with respect to these dedicated freight corridors. Now, this is a good opportunity to also talk about the industrial corridors. See, what we are trying to do is that we are actually trying to make industrial centers around the country. And we have proposed certain corridors, which would be the specific pathways for the overall industrial development in the country, right? So the government of India is developing several industrial corridor projects and dedicated freight corridors to boost the success of industrial cities, improve connectivity, decongest the existing rail network. So what we are trying to say is that we are actually having a symbiotic relation with respect to the industrial corridors and these dedicated freight corridors. So we are trying to basically make sure that there is synergy with respect to these 2 projects, right? So you can just see we have Delhi-Mumbai Industrial Corridor, we have Amritsar-Kolkata Industrial Corridor, different industrial corridors and economic corridors are there. And then we have got freight corridors which are mentioned in this particular map. Now, what are the different industrial corridors in the country? For example, we have got the Delhi-Mumbai Industrial Corridor, first and the most significant corridor aiming to develop high-tech industrial zones supported by Japanese investments, right? Spans across 6 states, Delhi, Maharashtra, Gujarat and other states. Then we have got Chennai-Bangalore Industrial Corridor, connects Chennai and other cities, focuses upon the industrial growth in South India with emphasis on automotive, electronics and textile. Please understand that Chennai is the sort of automotive capital of the country. And then we have got Bangalore, which is focused upon the information technology, right? So it is connecting all these nodes. Amritsar-Kolkata Industrial Corridor, so it connects Punjab to West Bengal along the Eastern Dedicated Freight Corridor, focus on agro-industries, manufacturing, services. Then we have got the Bengaluru-Mumbai Economic Corridor, connects Bengaluru and Mumbai to promote economic development in both the regions, primarily focuses upon the automobile, engineering and electronics sectors. Then we have got Vizag-Chennai Industrial Corridor, part of the East Coast Economic Corridor, aims to integrate Indian ports with industrial growth, focusing on chemicals, petrochemicals, and food processing. So that is what you need to know with respect to this particular article. So coming to the next article, it is with respect to the constitutional validity of the UP Madarsa Act, which was upheld by the Supreme Court in a recent verdict. So again, what the situation, the gist of the article is that we had the Allahabad High Court, which actually struck down a particular law, that is the UP Madarsa Act, and it said that it actually it flouted the principles of secularism, which are a part of the basic structure. But again, that petition was then submitted to the Supreme Court, and now the Supreme Court has said that it has reinstated the UP Madarsa Act, and it has given its own reasons. We'll see what the reasons are all about. So the Supreme Court has upheld the constitutional validity of the Uttar Pradesh Board of Madarsa Education Act of 2004, barring the provisions relating to the higher education. We'll see what are those provisions which are declared as unconstitutional, but most of the act has been declared as constitutional. So it actually overruled the Allahabad High Court's earlier ruling, which struck down the entire act for violating the principles of secularism. Now, what is basically this particular act? See, what you need to know first is what are madrasas. So madrasas provide both religious education in Islamic tenets, that is principles and practices, as well as mainstream secular education, right? So along with the Islamic education, they're also providing the mainstream education. And again, most of these madrasas are in line with the guidelines which are prescribed by the NCERT, National Council of Educational Research and Training. Now, the Madarsa Act of UP, this basically provided a legal framework for these institutions in Uttar Pradesh. The Uttar Pradesh Board of Madarsa Education was created with respect to, in line with this particular act, which prepares and prescribes the course material and conducts exam of all the courses. This particular act also gives the power to the state government to create rules and regulate Madarsa education. Why did Allahabad High Court quash this particular act? Allahabad High Court, what it said was that it violated the basic structure of the constitution. How? It says, Allahabad High Court said that it flouted the principles of secularism. And again, it said that in Kesavananda Bharati versus State of Kerala, the Supreme Court had held that the Parliament cannot alter the constitution's basic structure, the core principles of the constitution. And in S.R. Bommai versus Union of India, 1994, had ruled that secularism is a part of the basic structure. The High Court said that the act made it compulsory for students to study Islam, and more modern subjects were made optional. It also held that the state cannot discriminate by providing education based on religion. So again, if you have madrasa, what it is trying to do is it is also giving Islamic education. Along with it, it is also giving the mainstream secular education. So this particular act provided that Islamic education needs to be provided. So the court held that this is not in line with the secular principles. That is what the court said. The High Court also stated that the act violated the right to free and compulsory education, which is there in the Article 21A of the Constitution of India, by denying quality education in the modern subjects. It said that the board has the power, that is the Madarsa board has the power to grant degrees in Fazil and Kamil, right, which are basically equivalent to the bachelor's and postgraduate degrees respectively, right, under the act. Now, this is in conflict with the University Grants Commission Act, which is a central law and which takes precedence in the matters related to education. Why did the Supreme Court upheld this particular act? See, what it says, it said basically on three parameters. First is that basic structure test is not needed. What the court said, that constitutional amendments are tested against the basic structure, not an ordinary legislation. So if you have a statutory law, that cannot be tested with respect to the basic structure doctrine. Only constitutional amendments can be tested with respect to the basic structure doctrine. Now, this was actually highlighted by the Supreme Court in the Indira Gandhi versus Raj Narayan case of 1975, which pertained to an amendment to the Representation of People's Act of 1951, which was enacted to reverse the Allahabad High Court ruling to disqualify Indira Gandhi from participating in the elections. The amendment was then challenged for violating the constitution basic structure. And again, what the argument Supreme Court at that time gave was that the amendment violates the basic structure was too vague and indefinite to determine the validity of an ordinary law. In this particular case, the Madarsa Act case, for a law to be struck down for violating the principles of secularism, it must be traced to express the provisions of the constitution. That is, you cannot say that a particular law is violating the basic structure. What you have to say is you have to trace it to a particular provision in the constitution and then say that it violates the basic structure, right? Next aspect is that the state can regulate madrasas. So it has very clearly said that states have the power to regulate different madrasas so long as the regulation is reasonable and rational. States can regulate the aspects of education in minority institutions without violating the rights to handle the administration. The Madarsa Act, without depriving the education institutions of their minority character, is in line with this principle. Also, we have got the entry 25 of the concurrent list, which allows both states and center to enact laws on the subject of education, right? So it said that it must be seen in the broadest meaning and includes institutions that provide religious education. Right to education and minority institutions. So we had in 2014 where the Supreme Court actually heard the arguments with respect to the challenge to the constitutionality of Article 21A. So the court at that time said that the right of children to free and compulsory education must not apply to minority institutions. At that time, the court clearly said that, as it might destroy their minority character. The Supreme Court in the Madarsa Act referred to this particular decision, and it said that the High Court had made a mistake with respect to this aspect, and minority institutions such as madrasas have the right to provide religious education, and the administration can be carried out under Article 30 of the Indian Constitution. Why did the Supreme Court strike down the higher education provision? Right. So it basically said that Madrasas Act, that is the Section 9 of the Madrasas Act, which allows the Madrasa Board to prescribe coursework, conduct exams, and grant degrees like Kamil and Fazil, is contrary to the University Grants Commission Act. So we have got Section 22 of the UGC Act, which says that only universities which have been established under a center or state act have been deemed to be universities by the UGC can grant degrees. So now we have got two additional information which can be really important for your prelims, right? So we have some of the very important judgments of the Supreme Court talking about the basic structure doctrine. So we have got the case of Nanda Bharti versus State of Kerala. Now this basically established the basic structure doctrine and it ruled that Parliament cannot alter the basic structure of the Constitution under Article 368. Then we have got the Indira Nehru Gandhi versus Raj Narayan of 1975. It reinforced the basic structure doctrine, declaring democracy, rule of law, and judicial review as essential features of the basic structure. Then we have got the very famous Minerva Mills versus Union of India. This emphasized the balance between the fundamental rights and directive principles as a part of Constitution's basic structure. Then we have got the S.R. Bomai versus Union of India 1994. Over here, the aspect of federalism and secularism were actually declared as essential components of the Constitution's basic structure. Then we have got the very important I.R. Kolio versus State of Tamil Nadu case of 2007. It stated that the laws placed in the 9th schedule after 1973 are subject to judicial review if they violate the basic structure. So this you need to know. You can cite these cases in your mains answers as well. Now, let's also talk about the University Grants Commission. So this was founded in 1956 under the UGC Act. Now, this is the primary regulatory body for higher education in the country. The primary role is to promote and coordinate higher education standards, overseeing the university and colleges, ensuring quality standards are maintained in these higher institutions. The UGC allocates grants to universities and institutions for infrastructure, for research and development. Then, what if we talk about the affiliation and recognition aspect? It grants recognition to universities and colleges, making them eligible for academic and financial support. Next is, what are the key initiatives? So it includes schemes like the National Eligibility Test for teacher eligibility and several fellowships and scholarships. UGC now is actually focusing upon improving the digital education, implementing the new education policy, and the National Digital University. So we have the affiliated bodies. We have, for example, the National Assessment and Accreditation Council to assess and accredit educational institutions. So it collaborates with various other bodies so as to make sure that we have got a robust higher education system in the country. So that is what you need to know with respect to this particular article. So coming to the next article, this is with respect to the appointment of the state's Director General of Police, in particular reference with the state of Uttar Pradesh. Now, again, the UP cabinet has actually formed new rules with respect to the appointment of the state DGP, right? Now, some critics have been saying that they are not in line with the guidelines which were given by the Supreme Court. We'll see what this particular article is all about. So after the Aam Aadmi Party government in Punjab brought a legislation to independently appoint the State Director General of Police, the government in Uttar Pradesh has basically approved a similar guidelines for the selection of the state police chief, bypassing the center. See, what we have been seeing is that despite multiple reminders sent by the union Ministry of Home Affairs, the state has not formed a panel of senior Indian Police Service officers eligible to be appointed as state police chief as prescribed by the Union Public Service Commission following the 2006 Supreme Court judgment. So UPSC has prescribed the guidelines that you need to basically submit a list of the eligible IPS officers who can be promoted to the rank of DGP, right? Who can be made the state police chief. And that is in accordance to the directive which was given by the Supreme Court in the year 2006 in the Prakash Singh case, right? So, but the Union Home Ministry has been saying that the states are actually reluctant and they're not actually following the process. The cabinet in the UP cleared the Director General of Police UP Selection and Appointment Rules 2024 on Monday evening. Now, again, this decision comes before the Supreme Court is set to basically take a contempt case because many states, for example, we have got Punjab, Uttar Pradesh, Andhra, Rajasthan, they are actually appointing the ad hoc DGPs and they are actually not forming the guidelines, proper guidelines. Now, what you need to see is that these rules, the government is saying, the UP government is saying that these rules are in compliance with the Supreme Court verdict based on the petition which was filed by the former UP DGP Prakash Singh. Again, many people are saying that there is a provision in the 2006 judgment that directions to appoint the GDP through the UPSC will hold good till such time as the state or center enact distinct laws. Then we have got the incorporation of the Supreme Court judgment of the 2006 as well as 2019, which said that the officer should have minimum tenure of 6 months. Only it can be challenged that you don't have a member of the UPSC in this particular selection committee, right? But there are some critics also. So we have got the former DGP of UP, Sulkhan Singh. So he has said that these rules do not fulfill the criteria of police accountability and freedom from political interference. This is also against the 2006 Prakash Singh judgment. In 2019, the SC stayed the rules or acts framed by various state governments regarding the appointment, right? So it might be possible that the Supreme Court might also strike down this particular rule. The new rules propose the selection and appointment of DGP by a retired High Court judge, skipping the requirement to send a panel of 3 senior-most IPS officers to the UPSC. Currently, the committee to appoint the state DGP, it is headed by UPSC chairperson and includes the Union Home Secretary, Chief Secretary, and one of the heads of the Central Armed Police Force, not from the same cadre, right? So you need to remember this. Now, this is a very good opportunity to discuss about the very important Prakash Singh case, right? Now, this is one of the landmarks when we talk about the police reforms in the country. And that is the reason I've tried to highlight this particular case here, and this can be really important for your mains. So this case refers to the Prakash Singh versus Union of India 2006 judgment, which was delivered by the Supreme Court. As I said, the background of the case, it is with respect to the issue of police reforms in India, which were widely considered necessary due to the issues of corruption, political interference in the working of the police, and inefficiency in the police force. The petition was filed by Prakash Singh, a former police officer seeking directions from the Supreme Court for reforms in the Indian Police Service. Again, what you need to understand is that Prakash Singh filed petition under Article 32 of the Constitution of India, which allows citizens to approach the Supreme Court directly for the enforcement of fundamental rights. The petition asks the court to intervene and issue directions for the reform of the police force. Now, what were the ruling of the Supreme Court? Supreme Court issued a set of 7 guidelines which have to be followed by different states. So, Supreme Court judgment in the Prakash Singh case was a landmark in terms of police reforms. The court issued a series of 7 directives for the improvement of policing in the country. These directives were aimed at ensuring that police forces functioned in an independent, efficient and accountable manner. What are these guidelines? First is the directives. First is state security commissions. So the court very clearly said that each state in India should set up a state security commission. And what is the mandate of this state security commission? To ensure that police work is free from political interference. This commission was also responsible for laying down the broad policies for the police force and ensuring its functioning was in line with constitutional principles. Selection of the DGP, the Director General of Police, that is the highest police officer in the state, was to be appointed based on merit and seniority, and the process should be free from political interference. The DGP's term was to be fixed for at least 2 years to ensure autonomy in decision making and ensure that there is no political interference. Police Complaints Authority, the court also sought the establishment of independent police complaints authority at the state and district levels to look into the complaints made by the public against the police officers. This was aimed at making the police accountable to the public. Next is fixed tenure for police officers. So the police officers, particularly those holding senior positions, were actually to be given a fixed tenure. This would reduce the impact of political pressure and give officers the stability to make decisions without fear of transfer based on political considerations. Separation of investigative and law and order functions. Now, this is very important. The police forces were to separate the functions of law and order and criminal investigation. The issue with the policing in India is that both these functions of law and order, of basically maintaining law and order, and criminal investigations, they are both handled by the police. So there needs to be a segregation, there needs to be a differentiation. This would ensure that officers specializing in each area could focus on their expertise, improving the overall quality of policing. Next aspect was the modernization of the police force. The court said that a comprehensive plan for the modernization of police should be implemented, which would include the improvement in infrastructure, equipments, and technology. Next is welfare of the police personnel. The court also emphasized the need for improving the welfare of the police personnel, including better working conditions, medical care, and pension benefits. Now, what has been the significance of this judgment? See, first is that it has led to this notion of the independence of the police. Previously, please understand that we have had this notion that police is sort of an executive arm. It is a part of the executive, no doubt, but it is also accountable to the public, right? It has to follow certain rules and regulation. It cannot be interfered again and again by the political pressure. So that is what it is trying to say, that this judgment emphasized on the independence of the police functioning in the country. The judgment marked a significant step towards making the police force independent of the political influence. The establishment of state security commissions and the fixed tenure of senior police officers was meant to ensure that police could act without the fear of transfers and all these things, without undue interference from politicians. Accountability, the creation of police complaints authority aimed at making the police more accountable to the public and creating an avenue for the public to have a grievance redressal mechanism. Strengthening law enforcement, the separation of law and order from criminal investigation was expected to improve the efficiency and professionalism of the police force. Then the reform agenda. The court's directive were seen as a comprehensive plan for police reform aimed at improving training, working conditions, and the overall functioning. So when it comes to the police reforms in the country, believe me, Prakash Singh guidelines are the milestone, the most important milestone when it comes to the overall police reforms, and these guidelines can be very well used in your mains answer. So that is it for this particular article. So coming to the next article, it is with respect to the growing tensions between India-Canada relations. See, the overall gist of the article is that this article looks at the scenario with a very rational perspective along with reasons. It is not going into the emotive aspects, right? It is going into the reasons of why these diplomatic downsliding has taken place between India and Canada. So what the article says is that it only gives you the information with respect to the situation, right? It does not give you a fact which can be basically used in your answers, but it tries to explain the situation in a more rational manner. So recently, Canada and India expelled their top diplomats due to the fallout because of the Canadian Prime Minister allegations last year with that there were possible links of the Indian intelligence with respect to the killing of Canadian citizen Hardeep Singh Nijjar, right? India had categorized Nijjar as a Khalistani terrorist. Now, this escalated the Canadian Hindu-Sikh tensions. Now, is there a historical context with respect to this particular issue? See, Canada acts as a safe haven for Khalistani separatists and extremists, and its biggest grouse has been that Canada's failure in preventing the 1985 Air India bombing. So this was a very unfortunate incident which took place. And again, India has had complained. India has one of the most significant issues which India has with Canada is that it says that Canada did not investigate properly this particular bombing which took place in 1985. Lack of support in subsequent investigation. Now this led to the death of 329 people. Now, is it because of the vote bank that the Canadian government is doing that? So what the author says is that Sikhs constitute only 2% of the Canada's population. Political clout is far disproportionate. Why? Because of the geographical concentration. 4 Sikh ministers in the Trudeau cabinet, MPs from the Trudeau's Liberal parties, no public evidence to state that only motive for the Trudeau government to lay these accusations against India is to pander the Sikh votes. So again, what the author is trying to say that definitely it might be a reason, but it's not the only reason. That is, a vote bank is not the only reason. Evidence is the Trudeau government dropping word in words Sikh and Khalistani from the government reports. Khalistani extremism among the top 5 terrorism threats in Canada. Canadian Parliament marking Niger's killing by holding a moment of silence. Trudeau and other party leaders attending the Sikh Community Festival, which featured Khalistani flags, and glorification of Talvinder Parmar, the Air India bombing mastermind. So all these events have not been taken in a good light by Indian authorities. Then all parties, not just the liberal parties, have indulged in these kinds of acts. Now, what it tries to say is that it's not just the party, the Trudeau's party who is supporting these persons, it's even the other parties who have done so. Trudeau and his government have affirmed the territorial integrity of India. They have not explicitly condemned the Khalistani extremism. In surveys, what the survey says that 54% of the Sikhs in Canada intend to vote for the Conservative Party and 21% for the Trudeau's party, right? Now, the Trudeau government has already there have been issues with respect to, it is also suffering with respect to its failures in countering the Chinese interferences in Canadian elections. A public inquiry into the foreign interference has currently been instituted. So we have the Canadian newspaper, for example, the Globe and Mail, which exposed the Chinese interference and was about to publish the allegations regarding India. They have criticized Mr. Trudeau only for using serious national security issue for political grandstanding, rather than manufacturing the case to pander the Sikh votes as India alleges. So what the newspapers have mentioned is only this aspect, that you are basically doing all these, you are taking such a serious issue for political grandstanding, and you are basically not focusing upon this aspect, what India alleges, that to basically pander the Sikh votes in Canada, the Trudeau government has been indulging in all these activities. Are there political and cultural misunderstandings? Misunderstandings on the both sides have been there. So we have had, despite the fact that a vast majority of the victims of Air India bombings were Canadian citizens of Indian descent, the Canadian government for a long time had seen it as a foreign tragedy. Look how unfortunate it is that Canada actually declared that as a foreign tragedy, where you had its own citizens, Canadian citizens of Indian descent, who basically lost their lives. And the victims were not real Canadians. Therefore, there is the issue of systemic racism. Then the racial prejudice is also emphasized by the fact that despite being Canada's worst terrorist attacks, 90% Canadians had little or no knowledge with respect to this Air India bombing, right, of 1985. And more than 50% under the age of 35 have never even heard about it, right? The public is unaffected and ignorant of the Khalistani activism. Now, if you talk about the rule of law aspect in Canada, what you can say is the rule of law is enforced in a more systematic manner in Canada than compared with India. What the author says, the author also says the Canadian police independence is guarded. So we have got Ujjal Dosanjh. He is a former Liberal cabinet minister who himself was the subject to life-threatening attacks by the Khalistani activists. Now, he basically said that while the Canadian politicians have allowed Khalistani ideas to flourish, law enforcement has not been soft on the Khalistani terrorism. The Air India investigations failed to a large extent. The evidence on the hand does not suggest, as it is believed in India, that they were politically motivated. Now, the public inquiry that went into Air India bombing, now, this was very scathing, it was very serious, and it talked about the security and investigation failures in Canada, right? And it termed them as inconceivable, incomprehensible, indefensible, and incompetence, right? Additionally, India is angry that Khalistan referendums have been held in Canada and that Khalistani parades glorify the assassination of former Prime Minister Indira Gandhi. However, freedom of speech and expression is a much guarded value in Canada, and there is a high threshold of what constitutes a hate speech, right? So what the author is trying to say is that the limits to what constitutes a hate speech, they are different in India and Canada, right? The threshold is much higher in Canada. Referendums and non-violent separatism advocacy are legal in Canada, and referendums have been held to seek even the separation of Quebec from Canada. Burning the Canadian flag or the Bible in themselves are not criminal. Then what are the legal complexities? India's extradition requests for those who in terms as Khalistani terrorists are very often denied. They do not meet the Canadian legal standards. Western democracies are when it comes to the extradition, they're very cautious, right? So they're very cautious of extraditions to the countries with much poor human rights records. political dissenters and opponents in according to them, according to these countries, they are actually jailed for prolonged periods without adequate trial and bail under different laws. For example, we have got the Unlawful Activities Prevention Act, UAPA. Other reasons is with respect to the weakness of evidence solely relying on statements from the accused in custody. Then the inadmissibility of Indian intelligence evidence in courts abroad, as it is not gathered under Indian Telegraph Act and the Indian Information Technology Act, right? Only 6 wanted individuals have been extradited to India, right? And if you compare what Canada has been doing with other countries, so this number was 10 for the US and just 1 for the UK. Notably, what you need to focus upon is that India has not managed to secure the extraditions of Mehul Choksi, Nirav Modi, Lalit Modi, and Vijay Mallya. Now, you need to understand that the last 3 are from the UK, with which India has very good relations, right? What role the media has played? So, the Canadian media has asked some tough questions of the government and presented India's version about the dangers of Khalistani diaspora politics. Whereas in India, what we see is that the media in India, while rightly questioning the Western hypocrisy, has substituted the journalism with jingoism, uncritically pushed the government's narrative. Right. So these are the author's views, and they are saying that the journalists in India, they're not critical of with respect to this particular situation, and they are in a jingoistic mode. Right. It spread disinformation that nobody was convicted for the Air India bombings. Then we have got the other newspapers in Canada. So we have got the Globe and Mail that have asked Trudeau to provide more facts of his allegations last year, presently attacking him for being soft on overtly hostile actions of the Indian government and for curiously unwilling to acknowledge that India is, if not an enemy, yet is certainly an adversary, right? So these are some of the points, some of the arguments which have been presented in accordance with the kind of situation of rule of law you have in Canada and India, the kind of inadmissibility of the evidences, and what are the reasons why you see that there is growing hostility between India and Canada. So coming to the last article of the day, this is with respect to the statement made by Dr. S. Jaishankar, the External Affairs Ministers, and he has said that Quad will continuously grow, right? So what the article says is that no matter what the outcome of the US presidential elections will be, the India-US relations and the engagement with the Quad will grow. Now, he is in Canberra with respect to the India-Australia bilateral talks. Now, Jaishankar, he basically slammed the Canada over the violence outside the India consular camp, right? And he said that it gives space to extremist voices. Now then, steady progress, what he says is steady progress in our relationship with the US over the last 5 presidencies. When we look at the American election, we are very confident that whatever be the verdict, our relationship with the United States will only grow. Quad, which was set up post-tsunami in 2005, had been revived during the previous Trump presidency. For US, India, Australia, Japan is a very valuable strategic discussion. Now, this is a very important opportunity, a very good opportunity to discuss about Quad, right? So Quad, now this can be really important for your mains, this information. So Quad is basically formerly known as Quadrilateral Security Dialogue. Now, this is a strategic security alliance comprising the 4 Indo-Pacific nations, that is the United States, India, Japan, and Australia. The Quad aims to promote free, open, and inclusive Indo-Pacific region. The whole gist is that you have been witnessing since the 2000s the aggressive rise of China, more so in the Indo-Pacific region and more so in the Indian Ocean region. And in order to make sure that this aggression is stopped, it is restrained, we have got these democracies who have come together so as to make sure that there is the stress upon free, open, and inclusive Indo-Pacific region. The group has, again, the group is focusing upon ensuring peace, stability, and prosperity in this vital part of the world. The group had grown its importance as these nations seek to counterbalance China's growing influence in this particular region. If you go into the history and evolution of Quad, what you will see is that it was the idea of Shinzo Abe, former Prime Minister of Japan, Shinzo Abe, who proposed a broader Asia that would include India, Japan, Australia, and the US. The concept was, however, short-lived due to regional opposition and leadership changes. Then it was in 2017, what we witnessed was the rejuvenation. So the Quad was revitalized in the year 2017 with the involvement of 4 nations under a more structured dialogue. The strategic alignment among these countries had strengthened due to to the shared concerns about the security, especially with China's growing assertiveness in Indo-Pacific. Then we had the summit in 2021. The Quad leaders have held multiple summits, including the first in-person summit in September 2021, further solidifying the cooperation between these four countries. These summits have discussed various aspects, for example, the cybersecurity, new and emerging technologies, we have got the infrastructure development, COVID-19 pandemic response, and other things. Now, what are the key objectives of Quad? First is maintaining free and open Indo-Pacific. This is the most important aspect. So what we see is that members have been emphasizing the importance of ensuring that the Indo-Pacific region, it remains free from coercion and respect the international law. See, primarily it is with respect to the maritime freedom, and the region which is most important with respect to maintaining the maritime freedom is the South China Sea, right? So it is in the context of the Chinese assertiveness in the South China Sea that they are actually also focusing upon the freedom of navigation, right? Regional security cooperation. The Quad is focused upon fostering security cooperation in the Indo-Pacific, addressing regional challenges such as terrorism, piracy, cyber threats, and other issues, for example, natural disasters, promoting democracy and rule of law. Now, this is the ideological aspect of this particular Quad. The Quad aims to uphold the democratic values, strengthen the rule of law, which is significant to counter the authoritarian models of governance, particularly if you talk about the China's model of governance. Economic growth and development. The group seeks to enhance the regional economic cooperation, including through infrastructure development, technology sharing, trade partnerships, and other things, right? To promote sustainable growth in Indo-Pacific. Then we have got the Chinese to counter the Chinese influence. While the Quad is not explicitly formed to counter the China, the members share concerns about China's assertiveness in the region, particularly its activities in the South China Sea, its Belt and Road Initiative, and other efforts. For example, it has been indulging in debt trap diplomacy. It has been making, its extensive coverage in Africa or the South American countries, right? So again, what you need to focus is that India is the only country in these Quad countries which shares a direct land border with China, and that is the reason that India has been using its concept of strategic autonomy, right? And it has been saying that it has been saying very clearly that Quad is not against China per se, right? It is more for the balanced development or for a more free and open Indo-Pacific region, right? That is what India has claimed many a times. Now, what are the key areas of cooperation? First is security and defense. We have got different multilateral exercises. For example, we have got the Malabar naval exercises. Collaborate upon the defense-related matters to enhance regional security, right? For example, India has the Saga Doctrine, security and growth for all in the region. The cooperation is not aimed at forming a military alliance, but rather promoting maritime security, peacekeeping, and crisis response. Next aspect is the cybersecurity. With the increasing cyber threat in the region, the Quad nations to focus upon strengthening the cybersecurity cooperation, addressing issues such as data protection, digital governance, and the security of critical infrastructure. Now, this becomes really important because it was in the year 2020 that we had the discoms in India, the power distribution companies, which were attacked, and there were allegations that they were primarily the Chinese hackers. And similar thing even happened in the US. So there is a need for a more robust collaboration when we talk about the cybersecurity aspect. Climate change and clean energy. The Quad also emphasizes cooperation on the climate change, promoting the clean energy technologies, tackling the environment challenges in the Indo-Pacific region. Then infrastructure and connectivity. The group promotes investment in the regional infrastructure and connectivity, offering alternatives to China Belt and Road Initiative. For example, we have got the IPEF, Indo-Pacific Economic Framework, right? So that is basically a counter to Chinese BRI. The Quad aims to provide transparent, sustainable, and high-quality infrastructure in the region. Then we have got the health cooperation. The COVID-19 pandemic highlighted the importance of public health cooperation, and Quad has worked together to ensure that vaccine supply and address global health challenges. So see again, the different domains, there are very domains where the Quad nations are actually participating. But again, you must not forget that the basis of the formation is the growing assertiveness of China. So as to counter that aggression, we have got these four democracies coming together and forming a sort of a group, right? That is it for today. I hope you really enjoyed the session. Do let us know through your likes and comments. That is it. Thank you. All the best.